First of all, I would like to thank the organizers of the conference for having me here for a second year in a row. Notably, my topic today will be pandemics and religious freedom, so it is a special blessing that this year we're able to meet in person, as last year this was an online conference. The sole purpose of this talk is to discuss the interplay between government efforts to fight the pandemic and the obligation to protect freedom of religion. It is not intended to take one side or another on some of these more controversial issues. So I was joking with the organizer earlier that I'm going to upset everyone because I'm going to call it down the middle. Freedom of religion is recognized as a fundamental right in almost all of the major international human rights documents, including more recent treaties drafted for specific classes of people, like the Convention on the Rights of the Child and the Convention on the Rights of People with Disabilities. It's also obviously protected in the constitutional traditions of all 47 Council of Europe member states, including all 27 EU states. Freedom of religion is unique in that it is the only human right that recognizes the relationship between the individual and the transcendent. Article 9 of the European Convention on Human Rights, of course, protects freedom of thought, conscience, and religion. And for the sake of clarity, when I use the word convention or European Convention or Article 9 in the context of this talk, it will be in reference to the European Convention on Human Rights. So for those who aren't particularly familiar with international law, the convention has been adopted by all 47 Council of Europe member states. This means that ultimately the Strasbourg court has supervisory authority over compliance of the convention once domestic remedies have been exhausted. Textually speaking, freedom of thought and conscience are without limitation. If you look at Article 9, I'll try to get this back up here. So if you look at Article 9, the way it's split up, thought and conscience are without limitation from the second paragraph of Article 9. Well, that issue is an entirely different lecture. It is worth noting that it's dubious in some circumstances, certainly, that governments and courts do ignore rights of conscience across Western Europe. Nonetheless, again, that is a different lecture. One of which I believe we've already had earlier today. Now, freedom of thought is another one where we have an absolute right to think what we want, but the reality on the ground is that once we begin expressing those beliefs, governments come in and create things like hate speech. So that, in a sense, is not an entirely unlimited right either. But for the purposes of this lecture, we're most concerned with freedom of religion and religious expression. Now, as I just mentioned, the second paragraph of Article 9 does qualify, while it doesn't qualify freedom of thought and conscience, it certainly does qualify freedom to manifest religion. So for those who are familiar with the convention jurisprudence, you are already aware that Articles 8, 9, 10, and 11 are qualified rights in that interference is allowed where it serves a legitimate aim and is deemed necessary in a democratic society. For Article 9, it is not the case that the government can name just any legitimate aim as a matter of interference. In reality, there are 4 legitimate aims that are recognized in Article 9, paragraph 2. So for example, there have been cases before the court where, I believe it was with Bulgaria, where they cited national security as a legitimate aim for interfering with religious freedom, and the court found a violation saying that that wasn't an enumerated aim under the convention, and they struck that down. However, again, for the purposes of this talk, health is one of the enumerated aims, so I think it's uncontroversial to suggest that what we are dealing with here is a government's aim at pursuing health measures. So the question then becomes whether it's necessary in a democratic society. Now, before getting into my analysis, I would only mention that Article 9 is a multifaceted right. It protects both the forum interium, things like conscience and internal belief, as it does the outward manifestation of religious exercise. It protects, among other things, street preachers, the right to pray, the right to wear religious jewelry and clothing, which are of obviously a religious nature, to evangelize, and it protects the freedom to worship in churches as well as church autonomy. That leads us to today's topic. What happens to freedom of religion during a time of pandemic? Now, a great deal obviously has changed since 1914, the last time we've seen a pandemic of this nature, including our knowledge of virology and how we can prevent communicable diseases. Much of my lecture will deal with the United Kingdom, simply for the reason that this is the jurisdiction where I engage in these issues legally, and the reality is that Christian Legal Center, the company that I work for, has had 2 judicial reviews of church closures, one in England and Wales and one in Scotland, which I will talk about a little later. Now, the biggest restrictions to freedom of religion we faced in Britain were obviously the closure of churches for communal worship. The fact, and this one was a strange one to me, was that religious marriage ceremonies were also prohibited throughout the pandemic in England and Wales, and street evangelism obviously was stopped because that wasn't deemed an essential service, and people were forbidden to be outside unless they were going to work in pursuit of an essential service. Churches were allowed to broadcast their services, and most of them did. They were allowed to stay open for social outreach purposes, such as servicing the homeless. Now, as an initial point of analysis, I feel that it's fairly uncontroversial to suggest that the measures taken in closing places of worship in a number of EU member states, Canada and several EU states, and of course the United Kingdom as well, present a significant interference with freedom of religion and religious assembly, as well as church autonomy within the meaning of international human rights law. With respect to Europe, whether the closure of churches as an emergency health measure allow in and of themselves the right to derogate from the guarantee of freedom of thought, conscience, and religion under Article 9 is far less clear. Most Council of Europe member states, which took sweeping measures to combat the pandemic, including the United Kingdom, and I believe here in Poland as well, never availed themselves of the right of derogation pursuant to Article 15 of the European Convention on Human Rights by informing the Secretary General of the Council of Europe of their intention to do so or the measures they intended to take. Now, Article 15.3 of the Convention is clear as to this point, and I quote it here. Any high contracting party availing itself of this right of derogation shall keep the Secretary General of the Council of Europe fully informed of the measures which it has taken and the reasons therefor. It shall also inform the Secretary General of the Council of Europe when such measures have ceased to operate and the provisions of the Convention are again being fully executed. So furthermore, all EU member states and the UK have ratified the International Covenant on Civil and Political Rights. Now, none of these countries have made pertinent reservations in relation to Article 18 of the Covenant, which guaranteed freedom of religion, nor did they make any reservation to Article 4's provision that even in the time of emergency, public authorities are forbidden to derogate from Article 18 of the Convention. So in this sense, at least in a procedural sense, it cannot be argued that interference with freedom of religion as a means of combating the spread of the virus can be justified by emergency measures alone. Now, speaking specifically of the situation in the United Kingdom, and even before the first regulations were put into effect by the government to restrict fundamental freedoms in the government's efforts to slow the spread of the virus, the Church of England voluntarily closed its doors to public worship. Now, while it is accepted that the Church of England, as the recognized state church, may have asked for such measures to be put in place, this fact should not have negatively impacted the rights of non-state churches in ordering their own affairs. Now, in fact, the Grand Chamber of the European Court of Human Rights in the Lautsy judgment held that measures taken pursuant to a state church do not relieve a public authority of its obligations to respect all of the rights inherent in the Convention, including those relating to houses of worship. Now, even if a state church is to satisfy the requirements of Article 9, it must have in place safeguards to protect the rights of individual believers, including those of different denominations and faiths, because obviously Article 9 not only protects churches, it protects individual believers as well. Now, in the United Kingdom, the closure of churches for the purpose of participatory communal religious exercise, leaving them open for social welfare purposes only, not only secularized the purpose of churches, it sent a very public message that the government views the spiritual role of churches as secondary. While wholly indispensable and subject to nearly unfettered control over its own ability to operate freely. In other words, it views church autonomy as dead letter when it comes to pandemics. So precisely stated, the manner in which the COVID regulations were adopted did tremendous damage to the seminal principle of church autonomy and by extension to church and state separation. Now, while the restrictions on freedom of worship were not unique to the United Kingdom, they were certainly an indicator of the level of value the government esteems church attendance and participation in church life. Now, while at the relevant time, someone in the United Kingdom was free to purchase alcohol, both off-license and licensed, go to a bicycle shop, secure a loan, go to a chiropractor or dry cleaner or any number of other activities, church attendance, however, was punishable by a fine or forced removal to their home. Furthermore, while the government allowed churches to continue to function in their public outreach, providing services for the vulnerable, they clearly missed the point as to the primary spiritual role of churches. Sadly, it's just another sign of how we have lost the Christian heart of the United Kingdom. As I've already said, Article 9 is a qualified right and subject to limitations. However, those limitations must be, as I said, necessary in a democratic society, and they must pursue one of the four legitimate aims enumerated in the second paragraph of Article 9. Now, the court has defined the term necessary within the context of being necessary in a democratic society as meaning something more than desirable or useful. The Strasbourg Court has also said that there must be a proportionate means between the legitimate aim pursued and the means of achieving it. So the European Court has also held that any interference with freedom of religion is subject to a strict review of scrutiny. So for those who are American constitutional law scholars, you'd be aware of those two terms, narrowly tailored and strict scrutiny. Unquestionably, the pandemic created a unique situation we've not really seen in several generations, including since the European Convention was adopted. Many experts were ill-prepared for the task and gave potential death estimates which were exponentially higher than those which actually occurred. But governments should nonetheless be given the benefit of the doubt that the measures they took to combat the virus were done in good faith and for the legitimate aim of protecting public health. So the sole issue from an Article 9 perspective is whether sweeping measures limiting freedom of worship across Europe were a proportionate means of achieving a necessary end, and that being the service of public health. It's important to point out that Article 9 is not the only legal consideration when discussing lockdown measures. Now, European states, as especially you're aware here in Poland, are creatures of constitutional law, whether it be constitutional tradition, which we have in the UK because we don't have a written constitution per se, or an actual physical document. Basically, our constitutions provide the legal framework in which laws must function. If a law contradicts or is outside of the scope of the powers conferred by the Constitution, it is a law that is to be struck down eventually by the courts. If a measure at the domestic level, even when serving public health, cannot pass constitutional muster, just like any other unconstitutional provision, it must fall. Now, as with Article 9's question of proportionality, constitutional considerations and not government paternalism are the North Star which govern the questions of lawfulness. Now, what I mean by that is it's not enough just for a government to say, we're doing this because it's in your best interest and the best interest of the country. If the measure lacks constitutional support or is a disproportionate response to the legitimate aim being sought, as I said, the courts will likely strike it down. Now, COVID restrictions must therefore be proportionately engineered to serve public health without unnecessarily restricting freedom of religion. So, for example, sweeping measures which go well beyond what is needed would not be deemed proportionate under an Article 9 analysis. Moreover, restrictions must be rational. In Christian Concerns judicial review of the Scottish church lockdowns, the court struck down provisions of church closures precisely on the issue of irrationality. The Court of Session found that it was wholly illogical that you can go to a movie theater and watch a movie, but you couldn't go to church. Ultimately, it is not enough to say that lockdown measures affecting freedom to manifest one's religion or which limit worship are merely serving public health. Clearly, the factors of proportionality, constitutionality, and rationality are decisive. So it's worth looking at how jurisprudence other than that in the United Kingdom has dealt with the issue of church closures where legal challenges were brought. The proportionality of a similar lockdown of places of worship was considered by the administrative court in France, the highest administrative court in France, the Conseil d'État, in MW et al. The court found that the blanket ban on religious services in France was a serious and manifestly illegal infringement of religious rights under Article 9 and other French and international provisions. The same issue was analyzed by the Federal Constitutional Court of Germany in a judgment handed down on the 29th of April 2020, which was a challenge by a Muslim religious association. The court granted interim relief, permitting Friday prayers in a mosque on the grounds that a blanket ban with no mechanism to apply for exemptions was a disproportionate interference with constitutional rights. So right there, three of the major jurisdictions in Europe, UK, at least Scotland, France, and Germany. In the United States, similarly, the Circuit Court of Oregon in Elkhorn Baptist Church et al. V. Catherine Brown, governor of the state of Oregon, granted a temporary injunction suspending the lockdown of religious services. The court observed, and I quote again, the governor's orders are not required for public safety when plaintiffs can continue to utilize social distancing and safety protocols at larger gatherings involving spiritual worship, just as grocery stores and businesses deemed essential by the governor have been authorized to do so. So in other words, pastors and priests are just intelligent as business owners and can take the same measures to protect those attending from the spread of COVID. A similar claim was brought in Texas by Steve Horzay et al. In case 204-0249. In response to the claim, the governor of Texas issued an executive order which included churches on the list of essential services which were permitted to remain open. So what we saw, which was unique in United States and several states, which was not the case in a lot of other countries, was that churches were deemed an essential service, which again speaks to the level of respect the Americans still have for communal service as opposed to us in Europe. Now, further insight can be gained from the decision of the High Court of South Africa in De Beer v. Minister of Corporative Governance and Traditional Affairs. That judgment came down on the 2nd of June 2020. Now, the challenge in South Africa wasn't against church lockdowns per se. It was a general challenge of the lockdown measures taken in South Africa. And the court found at paragraph 7 of its judgment that in an overwhelming number of instances, the regulations were not even rationally connected to the legitimate aims that they sought. So again, rationality being, just like in the Scottish case, it makes no sense to leave cinemas open and churches closed. Now, while the South African lockdowns didn't affect places of worship because they were already exempt, I would argue, and I think pretty soundly so, that had churches been on the list of those under lockdown, that under the same rationality test, that law would have been struck down. Now, for the second part of my talk, let's briefly turn to the issue of mandatory vaccination schemes or government policies where vaccination passports or other types of certification limit freedom of religion. Let's turn first to the European Court of Human Rights and what it has had to say on compulsory vaccination. In a 2010 case, in Jehovah's Witnesses of Moscow v. Russia, the Strasbourg court held, and I quote, it's my first talk since COVID, and I didn't need these before. I think I need stronger ones. Free choice and self-determination were themselves fundamental constituents of life, and that absent any indication of the need to protect third parties, the state must abstain from interfering with the individual freedom of choice in the sphere of healthcare, for such interference can only lessen and not enhance the value of life. Now, 2 years later, in Somolkin v. Ukraine, at paragraph 33 of its judgment, the European Court found, and again I quote, compulsory vaccination as an involuntary medical treatment amounts to an interference with the right of respect for one's private life, which includes a person's physical and psychological integrity as guaranteed by Article 8, paragraph 1. Now, as I've already noted, several of the Convention articles, including Articles 8 and 9, 8 being the right to privacy, including bodily autonomy, and 9 being freedom of religion, are qualified rights. As such, while the court found that mandatory vaccines are an interference with one's right to bodily autonomy, it nonetheless left the door open for allowing mandatory vaccines if they served a legitimate aim and were found to be necessary in a democratic society. So then this year, in a much anticipated ruling, the Grand Chamber delivered its ruling in the case of Vyzwania and others v. the Czech Republic, in a case which dealt with mandatory childhood vaccination. As you would expect from the Strasbourg court, they gave a judgment which left no one happy. So while the first judgment to deal with mandatory childhood vaccination, it's really important to distinguish it from the case of possible EU COVID vaccination schemes. First and foremost, the Czech Republic already had exemptions in place from compulsory vaccination, including those for those children who had counterindication to the use of the vaccine. Exemptions were allowed on the grounds of secular conscientious objection. That is a big difference than what we're seeing with the COVID schemes across Europe. And as such, Article 9 wasn't even dealt with in that particular judgment because it was agreed that the parties never pled it. Second, the scope of the case was limited to only 10 historically well-known vaccines about which the public health authorities had a wealth of knowledge, verifiable data over a longer period of time, and prior clinical testing. Therefore, a strong argument can be made, particularly given these factors, that the Vyzwania judgment could not be stretched so far as to include the COVID vaccination. While Christians have divergent views on the issues of their faith and vaccines, the fact remains that there are Christians who refuse to take the vaccination because of their faith. Therefore, vaccination schemes which are essentially mandatory, whether strictly speaking or substantively so, I mean by having pretty significant restrictions on your ability to go and do anything in public life, like go to restaurants or be social, that clearly engages Article 9. So all that is necessary for an individual to have this, because as the Ueda court said, it's not required that a religious belief be a mandatory tenet of someone's faith. It is enough if you hold that belief seriously and cogently for Article 9 to be engaged. Now, one particular Article 9 objection to vaccine passports is that it creates a burden on freedom of worship and Christian education. Facility-based mandates or individual restrictions facing those who do not have COVID vaccination certification would do violence to the rights of churches, church organizations such as schools, and to individual believers. As I said earlier in relation to governmental outreach, paternalism, where laws are imposed on the supposition that they are in the best interest of the common good, but which cannot be evidenced as being necessary in a democratic society and narrowly tailored to safeguard essential freedoms, do not pass legal muster. Governments imposing such restrictions could therefore have to prove necessity, constitutionality, proportionality, and rationality in defending these restrictions. Significant moral and legal questions also arise from the fact that some vaccines, it's important, not all vaccines, but some vaccines have been derived using fetal cells harvested from aborted babies. Now, Christian Concern has addressed these issues involved in a recent video which we've uploaded to our website. Any of those interested in seeing it, please do visit our website at www.christianconcern. I would encourage you to watch it. It's quite an interesting discussion from experts in the field. It's important to note that pro-life beliefs, whether based on religious grounds or separate from them, are protected by Article 9 of the Convention. The taking of a vaccine which was developed with the use of fetal cells, the harvesting of which necessitated the destruction of human life, would be a serious issue of conscience for many people who identify as pro-life. Personally, I have no doubt that at some point this issue will get litigated, but at the end of the day, it really is just worth quoting the tried and true maxim that the barometer of a healthy democracy is the state of religious freedom in that nation. The sad reality is that in Europe, particularly Western Europe, the right to manifest religious faith in the public square has become significantly limited. What is perhaps most notable about the pandemic is that the principle of church autonomy, a principle upheld on 3 separate occasions by the Grand Chamber of the European Court of Human Rights in the last 7 or 8 years alone, have been largely set aside in the name of serving public health. Now, what is clear for those who are defenders of the faith in Europe is that we've lost a lot of ground over the last few decades. This was clear with how easily many governments were able to limit freedom of religion. Our collective challenge, therefore, is to reclaim fertile ground for allowing our churches to practice faith and to flourish. Without our churches, the common good cannot be served. In a world choking with unfettered individualism and vice, we need our churches more than ever. Let's pray that we've learned an important lesson from the pandemic, and we will value our freedoms far more greatly in the future, lest we lose them. Thank you.